Welcome to the 62nd session of the London-Leiden Conference, renewed after the lockdown and other hindrances. Could I say how good it is to see Francis Jacobs, who's not been well, and another absence is Margot Horspool, who's been largely responsible with Yolinda for organizing this this session. And I hope at some stage during the day we'll see Eva Evans, who I think is 100 or jolly nearly 99. Anyway, she says she'll come to see us. Now, I should ask, first of all, Spiros Maniatis, the director of the Institute, to say a word of welcome.
David, thank you so much. It's a great honor, pleasure to welcome you all to the Institute. I have to apologize because for personal reasons I had to travel and I cannot be with you this time. It's a great celebration, if you like, of a 62-year-old conference that remains current. Each year looking at the most fundamental legal, societal questions, the challenges that Europe is facing. I mean, the conference has seen so many changes, so many geopolitical shifts, so many crises, and what's happening today in Russia is another example. But as an EU citizen, as a European citizen that has been working in London for the last 35 years, I mean, the conference is older than I am, is an example of how it functions almost like an intellectual anchor that keeps the UK and the rest of Europe still close together. There will be many more conferences to come. Who knows how Europe will look 40 years from now, but I'm sure that London-Leiden will still be there. And I'm looking forward to see you all next year in Leiden. Thank you so much for joining. Enjoy the conference. I will be listening, following what's happening from a distance. Thank you.
Thank you very much, Spiros. Then now could I ask, well, Margot was going to join us on Zoom, but she is actually undergoing a procedure at this moment, but we would like, I'm sure, to send her our best wishes and ask Yolinda Bechirai to say a few words.
Good morning, everyone. Is this on? Yes. Thank you very much for pronouncing correctly. One of the few people for pronouncing correctly.
Well, you told me how, told me how it was done.
A couple of hours ago. So just a few words of context in addition to what was already said about the London-Leiden Conference. So the Europa Institute of the University of Leiden and the British Institute for International and Comparative Law annually organize a conference to discuss developments in European law. This year, it was already mentioned, is the 62nd anniversary of the conference, and the theme chosen, as usual, is a very important one. As an EU core value, the rule of law should inform the implementation of policies at the Union and at the member state level. But this, of course, carries with it important challenges that are felt not only in EU member states, but also in the UK. And despite the departure from the EU, as of the 1st of January 2021, the UK continues to be committed to the rule of law as a core constitutional principle, but at the same time, it faces similar challenges. Just to provide an overview of the structure of today's conference, there are some more programs on the table if you don't have one. The speakers of the first session on the rule of law as a foundational constitutional value will engage into a discussion on the fundamental constitutional principles that form the foundation of European liberal democratic states. So what capacity do the Council of Europe and the EU have to uphold the rule of law, and how has this changed in recent years? Also, how are the tenets of the rule of law understood in European liberal democracies, and what standards should be observed by these countries? Then the second session will discuss rule of law dimensions across EU policies and new areas, such as external relations, migration law, compliance with rule of law standards during emergencies, artificial intelligence regulation and the developments in this field, as well as youth engagement regarding the rule of law and democracy. Then the third panel is dedicated to the theme of the rule of law and judicial independence. And since judicial independence is an essential aspect of the rule of law, it's crucial that the judiciary remains independent both externally and internally. And so panelists will engage in a discussion of the potential challenges to independence of the judiciary in European countries, also in the light of the case law of the Court of Justice of the European Union and the European Court of Human Rights. So without further apologies, before that, I really wanted to thank again Margot for bravely insisting and consistently supporting us and the organization of this conference, as well the events team and all my colleagues that and everyone that is here today. Despite this being a Saturday morning. So without further ado, let me give back the floor to you for the beginning of the first session.
Thank you very much, Yolanda. Then to begin the first session, we have a very old friend, Takis Tridimas, who will speak about the ELI project and the findings of the working group.
Thank you very much. Thank you for the invitation. It's a great pleasure to be here. So my great thanks to the organizers. The purpose of my presentation is to say a few words about the project commissioned by the European Law Institute on fundamental constitutional principles. This was a project spearheaded by Sir Francis, who is with us today, and also Sir Geoffrey Jow. It is leading to a report, and what I will try and do is outline what the project is about, why we have engaged in it, and selectively present some of the principles, share some of our concerns. This is, of course, a collective project. Professor Elise Moore from Leuven University is the co-reporter, and we have a wonderful team. Professor Gestenberg, who is also here with us, has had a pivotal role in the articulation of the principles and the drafting of the project. And a number of other people have contributed. So what is the idea? The idea is to draft a report in the form of a charter which identifies and articulates the constitutional principles and standards which form the foundations of a European liberal democratic state. The underlying premise is that such a state is based on majority rule, but it is constrained by the obligation to respect the rule of law, including fundamental rights. The study has both a descriptive and a prescriptive character. The idea is to describe the fundamental constitutional principles as understood in European democracies following the Second World War, but also articulate standards which are expected from a genuine liberal democracy. So the project seeks to contribute to the contemporary public debate on the design and enforcement of core constitutional values in Europe. The idea, in other words, is to encapsulate contemporary European constitutionalism. Why do we need it? I think we need it for several reasons. First, a grave threat to democracy is the risk of complacency. Historical experience suggests that regression is possible. So the importance of restating constitutional values cannot be overstated. Secondly, there is an increasing realization that in contrast to expectations, globalization and interdependence of national economies has not brought about the intended benefit of political liberalization to all citizens. And it is indicative that in a number of reports by independent bodies in recent years, there is a realization that liberal democracies have decreased. One such report is by an organization called Our World in Data. This is an independent research organization that classifies countries in 4 groups: liberal democracies, electoral democracies, electoral autocracies, and closed autocracies. And it has identified a retreat in democracy. Whilst the percentage of countries classified as liberal democracies increased from 11% in 1970 to 23% in 2010, it has regressed in the last 12 years. The Freedom House, another such organization, reports that in 2018, the world recorded the 13th consecutive year of decline in global freedom. The war in Ukraine illustrates also in the sharpest possible way external threats to democratic states. Furthermore, the report attempts to capture contemporary challenges posed by populism and novel threats such as media manipulation and fake news. So we have articulated 36 principles. Some of them are principles of governance, others are principles relating to rights. They are grouped under the following heads: liberal democracy, the rule of law, judicial independence, checks and balances and accountability, dignity and equality, protection of fundamental rights, and constitutional integrity. Needless to say, I don't have time to go through the principles. The report counts some 104 pages. We articulate the principles and follow each principle by a short commentary. But what I would like to do is highlight some of them. The starting point of the report, as I said, is that a liberal democracy is governed by certain values. These are respect for human dignity, democracy, the rule of law, equality, and fundamental rights. A democracy is an ideology, it is a system of governance, and it is also a political culture. The term liberal democracy is not to everyone's liking. So we debated fairly extensively about this. The idea is not the attribute, the adjective liberal is not meant to indicate a preference for one political party or another. It is not a partisan term. It is instead used to indicate a polity that has political liberty and pluralism as its core values. So essentially, it has 2 attributes. It recognizes there are limitations on government and that those limitations derive from the need to protect the liberty of the individual. So liberalism places the individual at the center of the political system and embraces tolerance and a free political and social space for all members of society. As de Tocqueville argued, democracy is not only a form of government, but also a form of society, a society of equals. Very simply, there isn't really much originality in this. Very simply, the idea goes as follows. People are born free, therefore they cannot be governed without their consent. This in turn means that decisions have to be taken by a majority. It would not be practical to have direct democracy. So a classic Lockean understanding of political governance. But given that direct democracy, as I said, is impractical, we need to have representative democracy as an expression of majoritarianism. However, majoritarianism applies subject to certain limitations, and there are essentially three limitations. First, it only applies in relation to decisions which pertain to the social good. The idea is to ensure peace and prosperity for the citizen. This is what the government does. It is not the purpose of the government to lead us to salvation. Secondly, majoritarianism applies subject to safeguarding the freedom of the individual, since consent to be governed is not unconditional. It does not waive the essence, respect for the essence of rights. And thirdly, majoritarianism must be subject to mechanisms that correct the failures of the political process. And such failures may arise as a result of many considerations, bad faith, incompetence, and so on, so forth. We don't need to go through the specific possible grounds of review. So within that context, we articulate a number of principles pertaining to governance and principles protecting fundamental rights. Principle 3, for example, principle 1 talks about values, as I outlined. Principle 2 establishes the idea of representative democracy as the fundamental paradigm. Principle 3 talks about elections. Elections must be free, fair, and regular. Voting must be universal and secret, and the principle of one person, one vote must be respected. Now, it all sounds familiar and self-evident, but in fact, it isn't. And if one starts teasing out the aspects of free and fair elections, then I think one very quickly encounters difficulties. Universality of the voting means that the definition of the electorate must be inclusive. Here there are, I think, two groups that require closer attention, prisoners and non-resident citizens. There is, as you are probably aware, a juxtaposition between the European Court of Human Rights and the approach taken in this country about the prisoner rights. The report, in line with the case law of the Strasbourg Court, takes the view that persons who have been sentenced to imprisonment should not automatically be deprived of their electoral rights. The second group, non-resident citizens, it may also be controversial. The Strasbourg Court again has held that in principle, the imposition of a restriction on the right of non-residents to vote is compatible with Article 3 of the first protocol. But it has to comply with certain conditions. It's interesting to note here, I'm not providing a comment, to note here the judgment in Schindler versus United Kingdom, where the Strasbourg Court noted that while a significant majority of the contracting parties to the Council of Europe were in favor of an unrestricted right to vote of non-residents, the legislative trends are not sufficient to establish the existence of a common European approach. And on that basis, it concluded that a common European approach in relation to voting rights of non-citizens. And on that basis, it concluded that members enjoyed a significant margin of appreciation. The report takes the view that eligibility to vote should extend to all citizens who have a genuine link with the state, especially in relation to decisions which affect them directly. Personally, whatever my view is worth, I find the Schindler decisions, both at Strasbourg level and at national level, difficult to share. Principle 4 relates to political parties. They play a pivotal role in ensuring a functional democracy, and they must be able to carry out their activities freely. Citizens may freely form and belong to a political party. We also articulate some principles relating to political advertising, to the finances of political parties, and the obligation of political parties as independent entities to share and promote the values of liberal democracy. The internal organization of a political party must also reflect the principles of liberal democracy. Principle 6 talks about protection against disinformation. So the report includes not only principles and rights that one would expect to find in a classic constitution, but also tries to identify some political standards and address contemporary issues that states face. Principle 6 suggests that public authorities must provide an effective legal framework against disinformation. We have engaged in a very wide consultation exercise, sending the draft principles to a variety of organizations, all constitutional or supreme administrative courts in Europe, engaging with scholars on both sides of the Atlantic. And the message we get is that the principle of protection against disinformation should be strengthened. It should be further articulated in the report. One also faces some difficulties in defining disinformation, identifying what it means. Essentially, the idea is that it has a deceptive intent. Information is knowingly shared to cause harm, and that could include true information which is taken out of context, which fails to include material facts, or information which is labeled to arouse emotion. For example, the prioritization of divisive news or emotional arousing information may exploit decision-making biases and manipulate public debate. So the message we get, we need to strengthen this. On the other hand, there have also been voices, especially coming from US colleagues, which suggest that one needs to be very careful. It suggests that political parties have always engaged in a highly competitive information campaigns, and essentially what can be done now through information technology was always done through traditional means of party campaigning, so the distinction perhaps is not as clear-cut. We have a principle on proportionality. The idea is that the action by public authorities must be guided by that principle. So it is not only a ground of judicial review, it is more generally a principle of governance. Interesting, there has been a fairly recent decision by the Australian High Court, Palmer and Western Australia. This is a case where restrictions on traveling and on importation of goods imposed by Western Australia were challenged. The restrictions had been imposed in the light of the COVID pandemic. These were challenged by Mr. Palmer. Mr. Palmer is a tycoon who, in the who is who entry, lists litigation as his main hobby, and takes on many causes. So he challenged the restrictions imposed by the state of Western Australia. And I think what is interesting in the judgment, the court decided that the restrictions were justified. But what I see in the case is that the majority of them adopted a structured proportionality test, importing essentially the European standard to Australian law. This has not been uncontroversial. Earlier, was not accepted by all the judges, but it was accepted by the majority. The judgment has been criticized, and traditionally it has faced objections when imported in Anglo-Saxon jurisdictions. One commentator in Australia referred to it as an exotic jurisprudential pest destructive of the delicate ecology of Australian public law. As I said, the report takes that the view that proportionality is an overarching principle. And if I can say a few words to defend that, first, proportionality is a methodological tool. It does not dictate the result, it frames the inquiry. So it should be judged by how well it frames the judicial inquiry or the decision-making inquiry, not because it leads to a specific outcome. Secondly, in constitutional adjudication, balancing is unavoidable, even when courts say that they don't do balancing of conflicting rights or between rights and the public interest. In fact, I suggest this is precisely what they do. Thirdly, proportionality, I think, is particularly well suited to a legal system which is based on constitutionally entrenched rights. If you have a hierarchy of norms, then rights review is effects-based rather than objectives-based. And in a system which accepts that there are fundamental rights, then a review has to focus, at least to some extent, on the effects of state action on those rights, rather than simply on its putative objectives. And fourthly, proportionality is an umbrella principle which incorporates varying standards of scrutiny. It is not a mechanical principle, and I think one needs to look at the context and the standard of scrutiny which accompanies its application to determine how it is applied. Moving on from proportionality, we have included a principle on review of constitutionality, Principle 13, which states that courts must have jurisdiction to examine the compatibility of public measures, including legislative acts, with fundamental constitutional principles. So the report essentially takes the view that if certain principles are characterized as fundamental, then it should be recognized that they have higher legal force than ordinary legislation and, of course, subordinate legislation. And this essentially entails some possibility for the citizen to question at least administrative, the compatibility of at least administrative action with constitutional standards, even if that action is based on some statutory basis. Again, let's say through the consultation process, we haven't received any objections to this principle. I expected it to create more problems. We have a principle on accountability, on open government and transparency, a principle on good governance, and also a principle on anti-corruption. Principle 22 states that public authorities must take effective measures to prevent and fight corruption. And although this is not a standard or an obligation that finds ordinarily its way into constitutional texts, we think that corruption, especially if endemic, can undermine state institutions. Financially, can undermine them also from a functional perspective, in that rules are not correctly followed. And a number of studies proves that high levels of corruption weaken both democracy and the rule of law. We have a principle on non-state parties. The idea is that private parties whose activities substantially impact core elements of a liberal democracy may be subject to similar constraints as those that apply to the exercise of public authority. A very, if you wish, German view, but I think the drafting committee was unanimous in accepting the extension of fundamental rights obligations to non-state entities. We have included the principle of environmental protection and sustainability. Again, that's not evident, not all, by any means, not all constitutions follow that principle, although a number of them refer around the world, number of constitutions refer to environmental protection. They don't necessarily refer to rights, but we believe in a contemporary era and in the light of judicial developments in the Netherlands, Australia, Germany, and France, and indeed other jurisdictions, these ought to be elevated to a constitutional right, albeit not unqualified. We have a principle on automated decision-making, which has proved more controversial. The idea is that the use of automated means to take decisions which affect the individual must not undermine the safeguards and level of protection applicable by law to the rights or interests affected. So here, what we found through the consultation exercise is that there is a division between private and public lawyers. Private lawyers think that there is nothing wrong really with automated decision making. This is a matter that is subject to contractual freedom. Public lawyers, on the other hand, feel much more strongly that any use of automated decision making by the public authorities must have an express legal basis. I think the principle is phrased in quite cautious terms, but we continue to look at it. The idea, as I said, we phrase it in negative terms. The idea is that automated decision-making shall not prevent or unduly limit the exercise of the right to judicial protection of fundamental rights, and that the law must lay down the categories of decisions which must be subject to human review. As I said, this is a still work in progress. We are very happy to circulate the report if it has not already been circulated, and we would very highly value any comments received. We aim to submit it to the European Law Institute at the end of August, so there is still plenty of time to take into account feedback. The conclusion, if I can offer one, is that liberal democracy it remains, I think, something which is we need to engage with. I think vigilance is needed, and it is the regime which is more likely to lead to peace and prosperity than other ones. Thank you very much for us.
Thank you very much, Takis. That is extremely interesting. And I think all of us will probably look forward to reading this report. Can I go straight on to Professor Rick Lawson from Leiden, who is going to speak to us on Zoom?
Good morning.
Rick.
Can you hear me?
Yes.
Good. Good morning from Leiden. I really regret that I cannot be with you today. London-Leiden is always a family reunion, and one would like to be there, be present, and have the opportunity to mingle and have coffee and all that. When preparing today's session, I had to think back of one of the earlier editions, the 44th meeting of London-Leiden in 2005. The theme then was Past and Future of Judicial Protection in the European Union. Sir Francis, who I just saw, was one of the speakers. It was an exciting day, the day before the European Court had delivered its Bosporus judgment. So the paper was still warm and we had very lively discussions. I then shared a panel with Eleanor Sharpston, and if my memory serves me well, she had brought her mother to the conference, which we all thought was very sweet, and then sort of underlined that it is really a family reunion that we're having every year, be it in London or in Leiden. And I hope next time I'll be present in person. The idea that I had for my contribution, which I promise will be short, is to serve as a bridge between Takis' more conceptual explanation of the project that he is undertaking and the panels that will come next, which deal with substantive elements of the rule of law discussion. I would like to squeeze in a few more, if you want, institutional remarks about the two organizations that are actively involved in protecting the rule of law in Europe, the European Union and the Council of Europe, and look at their capacity to protect the rule of law, the famous toolbox, and make some remarks about recent developments. And I will be short. I think it's appropriate to start with the Council of Europe, as it was established in London on the 5th of May 1949, when the statute was adopted. Next year, May, we will celebrate, and I hope we can celebrate it in London, 75 years of the Council of Europe. Two bodies stand out. One is the Commission for Democracy Through Law, better known as the Venice Commission. I should be very brief on the Venice Commission because Murray Hunt is one of its members, substitute members. So the House knows everything about the Venice Commission. The Venice Commission is very active in shaping and giving substance to the rule of law. You've all heard of its checklist, which was adopted in 2016. Future will tell us whether the project that Takis has just brought was the very comprehensive project that the European Law Institute is now undertaking will lead to an update of this checklist of 2016, which is smaller, I would say, in its scope and ambition. So that remains to be seen. What I would like to mention today is I would like to ask attention for the series of reports that the Venice Commission has issued as regards Poland. Quite early on, when the rule of law crisis started to unfold in late 2015, early 2016, the Venice Commission was already involved, and I would say that the reports provide for fascinating reading. Unfortunately, they fell on deaf ears in Warsaw. They didn't lead to any changes, but in a way, what these reports managed to catch is these notions of decency and moderation, which I believe are at the core of the rule of law. Takis referred to a political culture that is underpinning the rule of law. Very much so. We are lawyers. We can try to identify specific standards like judicial independence and freedom of the press, but decency and moderation, which were so much lacking in Polish politics in 2015-16, are mentioned in a beautiful way, I would say, in these reports. When turning to the European Court of Human Rights in Strasbourg, in recent years, it has been very active when it comes to judicial independence. I will not say anything about it because the panels of this afternoon will be about that very much. I would merely say that the court has been both early and late when it comes to the rule of law. It was early in the sense that already in 1975, in the case of Golder against the United Kingdom, the court referred extensively to the rule of law as one of the foundational values of the Council of Europe, one of the foundational values of the European Convention of Human Rights. And the court said already then, 1975, that the interpretation of the convention should be guided by the rule of law, which inspires notions like access to justice and the foreseeability and legality of government action. So the court already at an early stage started to develop the rule of law and apply the rule of law when interpreting the European Convention. On the other hand, the court, I must say, was terribly late when it comes to the current rule of law crisis. Problems in Poland started in 2015, yet it was only in 2021, some 5-6 years later, that the court delivered its first judgment as regards Poland, the case of Zero Floor. 6 years, and when time is of the essence, when facts are taking place on the ground, then every year is one too many, one would say. When we look at Russia, the foreign agent law was adopted in 2012. It was only 10 years later, in the case of eco-defense of 2022, that the court found that this law was in breach of the European Convention in many ways. So I would say for an early warning system, which the court was meant to be from its very inception, that's not a very good record. The court failed to intervene when time still remained to do something about the developments in these countries. And of course, the court suffered from a huge caseload. It has a lack of personnel and a lack of capacity to deal with all the cases that are pending. But I think, especially in hindsight, it is fair to say that the court did not give the necessary priority to these cases, which were so much about the capacity of states to protect fundamental rights and maintain the rule of law. It should also be said that the Committee of Ministers of the Council of Europe, which has the responsibility to supervise the execution of judgments of the European Court, was not always as sharp as it could have been. So it is convenient perhaps for states to lean back and outsource the protection of human rights and the rule of law to institutions like the European Court of Human Rights or the European Commission of the EU for that matter, but outsourcing is not always sufficient. States also need to invest politically in maintaining the rule of law. Turning to the EU, much has been said and much will be said today about the toolbox of the European Union when it comes to protecting the rule of law. The Article 7 procedure, which has been used as regards Poland and Hungary, the series of infringement proceedings that the Commission started against these and other countries, preliminary rulings like the Chalmer case. I have no doubt that all this will be discussed this afternoon. One or two remarks about the EU. The EU has been developing its toolbox when it comes to rule of law. One notable milestone is the conditionality regulation of December 2020, regulation 2020/2092, which for the first time provides for a definition of the rule of law in a legally binding document. We had the checklist from the Venice Commission, we have Taki's project, but here we have a regulation which in Article 2 defines the rule of law, at least for the purpose of that regulation. It's by no means the final word on what is the rule of law, to the extent that we can have a final word, but at least by singling out 6 elements: legality, legal certainty, the prohibition of arbitrariness, the principle of effective judicial protection, separation of powers, and non-discrimination, the Union has defined a number of core elements which will continue to play a role in the foreseeable future. Now, as we all know, Hungary and Poland disagreed with the adoption of this resolution. They brought an annulment procedure before the Court of Justice, which in a way backfired tremendously because in February last year, the court delivered its judgment in the two cases, C-156 and 157/21, which led to important judgments on the rule of law. Just to quote one, I believe, crucial consideration of the court, paragraph 126 of the case brought by Hungary. It follows, the court said, compliance by a member state with the values contained in Article 2 of the Treaty on European Union is a condition for the enjoyment of all the rights deriving from the application of the treaties to the member state. A condition for the enjoyment of all rights. The court added, compliance with these values cannot be reduced to an obligation which a candidate state must meet in order to accede to the European Union and which it may disregard after its accession. A very strongly worded judgment, which is, of course, worthy of close consideration and study. One of the questions that we will be discussing, no doubt, today and in the coming weeks and months is the extent to which the values contained in Article 2 of the Treaty on European Union, including the rule of law, can serve as a ground independently for union action when these values are under attack. Do we need provisions like Article 19 of the Treaty on European Union to give concrete expression to the values of Article 2 and enable the Commission to take action? Or is the mere violation of the values of Article 2 in itself sufficient to take action against the member state? I think this will be a debate that we will certainly have when it comes to current situations. As we all know, the Commission has brought infringement proceedings against Hungary for its legislation on LGBT rights. Many member states joined the Commission as third parties supporting the Commission. There we already have the question what the legal basis is for the Commission's action, and the same may occur when the Commission actually brings infringement proceedings before the court as regards Poland and this new, as it is called, the Lex Tusk, about vetting individuals who want to stand in elections as a candidate. Future will tell. Much more could be said, but I won't for the interest of time. We should also leave time for questions. Many initiatives are on the way. The Defense for Democracy package is relevant for rule of law. One thing which might be overlooked, but I like to mention it here, is that the EU's Fundamental Rights Agency in Vienna has just adopted a new strategy for the years ahead. And the rule of law crisis and the principle of effective judicial protection, judicial independence, feature very prominently in the new strategy of the agency. So it reflects, I think, a growing concern amongst EU institutions as well, that the rule of law should be protected. A lot is on the way, but I would agree with Takis that there is no reason for complacency. There should never be a reason for complacency. I have to think back a lot of times to the speech of Sir Winston Churchill in Zurich in 1946, when he called for the United States of Europe. And Sir Winston made a very interesting remark and also a dark warning when reflecting on the demise of the League of Nations, which had been unable to prevent the Second World War. And Sir Winston said, and I quote, and I think it's a lesson that we should heed even today, the League of Nations did not fail because of its principles or conceptions. It failed because those principles were deserted by those states which brought it into being, and because the governments of those states feared to face the facts and act while time remained. This disaster must not be repeated. And I think that he was very wise in saying this. One often does not get a second chance in life, but I do hope that the EU and the Council of Europe will act decisively when it comes to the threats to the rule of law that are currently present on our continent. Thank you.
Thank you very much indeed. Right, we have a little time for questions. Yolanda will keep me in order in that respect. Anyone got a question at this stage? Well, perhaps I could ask a question then. How far are you taking account of the position of the lawyer, in French terminology, auxiliaire de la justice? What position do you offer to the lawyer as an essential element in the rule of law?
Yes, Julie, thank you. There is a passing reference. One of the sections of the report pertains to judicial independence and the rule of law. And there in the commentary, we have a passing reference to the importance of lawyers. But I must say that we have received a response from the CCB, which thinks that we don't say enough about the importance of lawyers. So we would need to boost that up. That's a very interesting point.
Thank you. Yeah. Rick, have you any comment on that? No.
So also it's a very valid point. The position of lawyers is important. And there is an organization called Lawyers for Lawyers, as we also have an organization called Judges for Judges. Lawyers for Lawyers is a very interesting NGO set up by lawyers, seeking to protect the position of lawyers who are quite often under pressure, who in many countries are prosecuted. And we have seen examples in Turkey, for instance, where lawyers who were defending dissidents, opponents of the government, that they themselves became the target of sanctions. And they do perform a key role in a democratic state governed by the rule of law. And actually, Lawyers for Lawyers has adopted guidelines on the position of the independence of lawyers, which I would certainly recommend to Takis and his colleagues when they develop their project.
Thank you. Any questions? More questions? Well, can I just pursue this thought then? There is, it's not just a question of lawyers being a part of the legal process. It's also the freedom of the lawyer to say what has to be said. I mean, we have had very recent examples in Russian courts of lawyers simply being shut up by the judge. And I wonder whether you contemplated not just reference to the lawyer, but also the necessity that the lawyer should be able to say what has to be said, because that issue is a very fundamental issue, because the corresponding obligations of the lawyer not to say, not to mislead, not to overburden the process of justice.
Yes, a point taken. It's and I think this is what the CCB has also pointed out. The idea that lawyers should be free to exercise the power of legal representation, that they should suffer no adverse consequences in this respect. And the issue has also arisen, as you rightly point out, in Russia, it has also arisen in relation to lawyers who take, within quotation marks, their own causes. So there have been examples, for example, over the last 12 months of lawyers supporting Russian interests, for example, in the context of sanctions, who have been subject to extensive abuse, including, in fact, extensive abuse through social media, including, in fact, some barristers in this country. And you're absolutely right. We need to take that on more. It's also a reflection. I was talking to Sir David earlier. how difficult it is to take on the state as an individual, even in countries which are very liberal, such as the United Kingdom. It has a tremendous tradition of judicial review. Ireland, a case where judges are fiercely independent. And I would say this, I would put those countries in the higher end of the spectrum within Europe. There are other European countries which are deeply democratic, but courts and the legal profession are perhaps less likely, less used to taking on the government. But even in countries with liberal tradition, and I would include the EU in that, it's a legal system which is favorable to the individual. It's still extremely difficult to take on the state, whether it is a national authority, whether it is the European Union. The odds are very, very much against it. And I think we need to be very aware of it. So the idea of access to justice, the idea of legal aid, these are not theoretical principles. They do make a tremendous difference on the ground.
Thank you, Takis. Any questions? Any further questions? Oh, good, two. Right, take this one first. Yeah.
Can I have one question for each speaker or not?
Sorry?
Can I have two questions? One for
Yes.
each speaker. Okay.
Okay,
So
yes.
I have one question for Takis, and especially on the distinction between open government and transparency, because you said that you have this principle there. So what does, because I'm pretty interested in that distinction. And for Professor Lawson, the question is, can you comment more on the Commission in action in certain cases? I mean, obviously, you are talking a bit about, you know, the shaky legal grounding to take action against the LGBT law in Hungary, but the Commission has very much grounding to take action against Romanians, you know, inactivity in LGBT. There is a case called Coman that is not follow up at the national level. Moreover, in Hungary, we have the CU case that is not actually, you know, have given any importance on the national level. So maybe that if you comment on that, it would be great.
Thank you. Perhaps we should find out what the other question is at the same time.
Hi, yeah, just I suppose just pushing against slightly the idea that the UK is at the higher end of the spectrum around these kind of things with respect to the protection of lawyers and the role of the lawyer within protecting the rule of law. Just on, I think we can see from the abuse that was directed at the lawyers who were litigating in the Rwanda case, that was actually then stoked by ministers, and there was language around lefty lawyers being an extension of the human traffickers, aiding and abetting the human traffickers. And that then, I would say, led, you can perhaps make a causation argument, but that would then led to an attack on the legal office, the Duncan Lewis solicitors firm, their legal offices in London. So I think there's a real problem there with the abuse of lawyers being state-stoked, if you like, in the UK, which was traditionally a leader in these areas. And I think a real problem there for the rule of law and how it's seen to be protected in those ,countries, as you said, who were the inaugural countries 75 years ago. Thanks.
One other question, and then we'll have to.
Sorry, it's just to confirm, you know, the comment and the question. I think there's also an issue with legal aid and access to justice in this country. So I would completely agree with what was just said. Yeah. Thank you.
Okay. Right. So now we're limited in time. Each of you, Takis, would you like to respond?
Thank you. Yes, very quickly, I'm taking the comments and the questions in the reverse order. In relation to the last two comments, I fully appreciate the points that you raised. I believe that they're real issues. Now, in the context of the report, there is what we are doing is we are articulating principles. We are heralding moderation, as Rick said earlier on, dialogue, tolerance. We are articulating principles by reference to certain either hypotheticals or specific exams. We have not included any of the exams that you mentioned. I think it is important to make sure that the report is endorsed by the European Law Institute, which represents a wide constituency, it is difficult to make sure we get a consensus over these principles. So I will put it to you differently. It is not possible to draft constitutional principles that would be acceptable to everybody in the world. It's unfortunate, but it is correct. We cannot have a document which will be meaningful and will be subscribed by an American politician and politician from Russia, from Iran, and from Europe. So a constitutional document represents an ideology, but it has to be at a sufficient level of abstraction, and it cannot remedy necessarily all wrongs. But thank you for the comments, and I fully take them into account, and I share them. Juana, you're right. I think briefly the answer to that is that open governance is more of a standard. Transparency can be more specific. It can lead to specific obligations. Very quickly, we articulate 4 sub-principles, if you wish, under that heading, that government bodies and state entities must exercise public functions as openly as possible, must conduct their work as openly as possible, that the decision-making process at all levels of governments must observe the highest possible level of transparency, that the law must enable stakeholder participation through information, consultation, and engagement, and an open dialogue should be maintained with citizens and representative associations, and individuals and legal persons must have the right of access to documents held by state authorities. These are the 4 principles which are articulated, and then there is a bit of comment to do. Thank you.
Thank you. Rick, would you like to comment?
Yes, with pleasure. True, the Commission has been criticized for being too late, as in the case of Poland, or to be absent, as in the case of Romania, or maybe Malta, or other countries experiencing problems. Of course, the Commission enjoys discretion, whether to bring infringement proceedings or not. It has always had this discretion. But the Commission has been accused of being too political or having weak knees and failing to act when time remained and the conditions called for a firm response. I understand all this, but I would like to make 4 arguments in a way to defend the Commission, just to show the other side of the debate. One is that actually the Commission was early. In the case of Poland, when the constitutional crisis started to unfold early December 2015, already in December 2015, the Commission started a dialogue in the context of the so-called rule of law framework, which was construed a couple of years before as a sort of first phase before an Article 7 procedure might be started. So I think credit where it's due. Frans Timmermans and his cabinet were really actively following and being involved in the situation in Poland. You might say it was not enough. What is a rule of law dialogue if it only buys time for a bad intentioned government? But the Commission was earlier than many people appreciated. The second thing that I would like to mention is that the Commission must have observed that when the Article 7 procedure was brought, first against Poland, then against Hungary, it actually went nowhere. Apparently, there is not a sufficiently large majority amongst the member states to do something about the situation in these 2 countries. The political will is not there, at least not amongst a sufficiently large number of states to get to the next stage of the proceedings. And we don't need unanimity or quasi-unanimity for that, but still the numbers were missing. Now, if the Commission sees this, that at the political level, the member states are not giving this sufficient priority, then it may not be an encouragement for the Commission to take risks, to expose itself and engage in a confrontation on these highly sensitive matters with the member states. It is only so far that international institutions can go. What I found extremely worrying and telling is that when the court, the Luxembourg court, which always enjoyed great respect in member states, indicated interim measures towards Poland and even imposed penalty payments, daily penalty payments on Poland, it didn't change a thing on the ground, which shows that even a highly respected institution like the Court of Justice in Luxembourg has apparently certain limitations to its powers, and these limitations become all the more apparent if the member states are absent. Third, more technical, what was the legal basis for the Commission to act? As the person asking the question mentioned, somewhat shaky. The Commission wasn't quite sure what the legal basis would be, and it was only after this Portuguese judge's case that the court realized, or that the court paved the way by creating this link between Article 2 of the Treaty on European Union, Article 19, Article 47 of the Charter, thereby indicating to the Commission that it could bring these infringement proceedings on this footing. But it took a while for the Commission to develop these ideas. Lastly, I think we should raise the question how much external actors can do when things go wrong in a country. After the Second World War, we liked to believe that we had created these very strong safety nets, the European Convention, the EU containing and constraining states, but we now have to experience that there are limitations to what these safety nets can do. And if there is no change in the country itself, if Mr. Orban is re-elected and re-elected, if Mr. Erdogan is re-elected, if the peace government is re-elected, then there is only so much that external bodies can do. Now, all this is not to say that the Commission could not be more proactive. I would certainly agree that the Commission would, and I understand fully those who try to put pressure on the Commission to do more. And I think the Commission needs this pressure. It needs to be seen towards other states that it is under pressure from NGOs, from academia, from opposition members. But at the end of the day, the EU is not a human rights institution per se. It has a different DNA. And I think in a way, although it's not enough, the glass is not completely empty, it is also half full, and a lot has been achieved.
Thank you very much. Well, as always in London-Leiden, we're running slightly over time, but can I suggest we come back at 11:30? Is that okay?
So coffee served on the back, so we have time to change the plates, and maybe
Yeah,
we can start a little
that's
bit
good.
earlier.
Okay,
Thank you.
thank you.
Thank you very much to our distinguished chair, the distinguished speakers. Thank you very much to Professor Lawson for joining us from Leiden. Thank you
Okay,
so much.
thank you very much.
Thank you. Goodbye.